Thank you very much for the invitation and for the introduction. In my normal day-to-day work, I have graduate students that work in collaboration with the radiology department in the hospital, and we do the same interesting flavor of medical image analysis that you've heard quite a bit about. But here I'm going to talk about my hobby, which is, as Bart said, the interplay between law and technology in connection to the use of data. I'm going to tell you a little bit about anonymization of medical data and some issues that surround anonymization of medical data. So let's start with the fundamentals. This talk is going to have 4 parts that are variations on the same theme. The first one is the longest, so I think, so you can be optimistic. Anonymization comes for a problem, to solve a problem. And the problem is that many of us, when we want to do medical image analysis or medical research of any type, we need data. But the data is confidential. That's the tricky part. There is all this data, but as researchers, it is often very difficult for us to get access to this data. And anonymization or de-identification, these are similar concepts, comes or attempts to come as a solution to the difficulty of confidentiality that is on the data. So we hope that once the data is anonymized, we will not be concerned with the confidentiality anymore, and we will be able to use the data for whatever we want. So this is the raison d'etre for anonymization. And what is the basis? So one basis is medical ethics. Medical ethics is regulation of the medical professionals by the medical professionals themselves. So we call it ethics because, not law, for example, because the regulation is internal to the medical community. So we go, there is something called the World Medical Association, which issued the Declaration of Helsinki many years ago, after World War II, and it has gone through several revisions, and it is more or less, for those who don't know, this is more or less the standard for medical ethics, and it is said there that for medical research using identifiable human material or data, physicians must normally seek consent for collection, analysis, storage, or use. And the stress is on identifiable because from the point of view of medical ethics, once the data or material is not identifiable, you can do with it, or the physicians can do with it, whatever they like. So once we anonymize the data, hopefully we will get away from these constraints of medical ethics, and we will be able to do the data whatever we want. This is also in law. Law is different from ethics because law comes from the sovereign, whoever this sovereign is, and applies to everyone. If we go to the United States, the applicable law is called HIPAA, for Health Insurance Portability and Accountability Act. There is, in this huge old phone book of a law, there is something called the privacy rule, which is the fundamental US law on privacy. And it says there, protected health information, this is an American term, protected health information means individually identifiable health information, which means that if your data, the data that we're talking about, is not individually identifiable, then it is no longer of concern for US law. Similarly, in Europe, we are now in Europe under the GDPR, the General Data Protection Regulation. It says the principles of data protection should therefore not apply to anonymous information. So once the data is anonymous or rendered anonymous by act of anonymization, the GDPR is no longer of concern. And for many of us, this means we can have some air because the GDPR is considered very limiting in some contexts. So let's move, since we've talked about de-identification, let's now talk about re-identification. Re-identification is the inverse process. You take anonymous data, and now you are re-identify the person to which this data applies. This sounds crazy, doesn't it? To be able to do re-identification. Let's talk about it. We have here two heroes in this story. Here on our right is William F. Weld, a very popular governor of Massachusetts, Republican governor of Massachusetts. This is a big thing in 1997. Nowadays, he's a presidential nomination candidate for the Republicans, which means that he's going against Trump for the Republican nomination. A very interesting person. And on the left is a lady called Latanya Sweeney, which at 1997 was a graduate student in computer science at MIT. And nowadays, she's a big name in connection to privacy in Harvard. And that's their story. We are now in 1996, 1997. Governor Weld lives in Cambridge, Massachusetts. That's where all these famous universities near Boston are. It's a city with a population of 54,000. And as the governor of Massachusetts, he has health insurance, like all the government of Massachusetts employees. They have an insurance company called GIC, and the insurance company provides medical services to state employees, including the governor. And as a socially responsible company, they release anonymized health records to researchers. What do? They cross the names and they cross the street address from the medical records and hand them out to researchers, okay? Now what Latanya Sweeney does, she goes and buys for $20 the Cambridge voter rolls. These are the list of all the people who are eligible to vote in Cambridge. It includes name, address, zip code, date of birth, and sex. So now she has that. What does she do? She finds that there are 6 people in Cambridge that share Weld's date of birth. Date of birth was not erased from the medical records. Of them, 3 are male. Gender was not erased from the medical records. And only one has the same zip code as Weld, because the zip code is not part of the street address, so it was not removed from the health record. So now she knows exactly how to find Weld's health record in this collection of anonymized health records. So what does she do? She prints out the health record and sends it by mail to his office. And after that, the HIPAA privacy rule was revised in 2002 because the Americans discovered the hard way that their anonymization techniques were not really relevant. When this topic is studied from a computer science point of view, there is a big field called differential privacy. I'm not going to get into it. The main claim is that if you hold a database with confidential information and you allow people to ask statistical questions about the database, if you provide answers, too many answers that are too accurate about the statistics, all the privacy will be gone. People will be able to detect and recover all kinds of confidential information from your confidential database if you allow them too many statistics, which means that if you really want to protect the privacy of people in the database, you need to inject noise into the data. For example, if you ask what is the date of birth of someone, you would not say July 25th. You would say the last 2 weeks of July. That's the kind of noise that is typical. We will not get deeper into that. Instead, we will talk about k-anonymity. Here is Sweeney again for k-anonymity. Let's go to, I'll do it by example. Let's go back to Weld's case, Sweeney and Weld. If Sweeney would have only be able to discover that that Weld is one of six people for whom she holds health record, so she doesn't know who the real Weld is between the six records. We would say that the K value is 6. If we also give Sweeney the gender and she knows that Weld's health record is one of these 3 health records, we would say that K is 3. If we give her the zip code and she knows exactly that this is Weld's health record, K equals 1. Of course, for anonymization, you want K to be as large as possible. And if we go to applications of this concept, there are now Israeli guidelines that are proposed and discussed, and they require health data released to the public to be anonymized to K greater than 20. So this is the kind of language of K anonymity. In the revised United States law, if you want to disclose confidential information that has been anonymized, you have 2 ways to guarantee yourself against someone who is going to sue you. One is to provide an expert opinion, some statistician, who will say that when you release this data, the risk of re-identification is very small. Of course, it will not be easy to find a statistician who will want to provide such a statement, and he will charge a lot of money. So instead, you can use a safe harbor method, which means you have a list of 18 types of identifiers that you have to remove: name, address, email, photo, whatever. And once you remove these 18 identifiers, you are considered okay by the law. The question is your data still useful after all these identifiers have been removed? For example, if you consider, say, cases of lung cancer, then without some of the data that has been removed, you might have known that all these cases are concentrated in a small area around a polluting factory. Once the data is removed, then perhaps you don't know that anymore. In Europe, the European Union is very strong in inventing new English words. There is something called pseudonymization. That's an EU parlance. The idea is to replace identifying data like ID number or name by a token. And then you have a table that relates a token to an identifying data item, and you hold this list, this index, in a safe. This is pseudonymization. What is the benefit? If you don't have this list, you don't have access to the list, then it's, for all practical purposes, anonymous. But, for example, if you have someone in the list who you know has some disease for which there is no cure today, but tomorrow there will be cure, once the cure is found, you can go to the safe, open it, find out whose data is, to whom this data belongs, and then go to him and tell him, well, we found a pill that will make you young, beautiful, and happy again. And of course, once I burn this index, the data is completely anonymous. I cannot de-identify anymore. Alternatives to anonymization, perhaps Bart discussed yesterday generative adversarial networks, GANs. Did you? No. So the idea is, in the same way that we create fake images, fake videos, fake speech, fake music, fake everything, the idea is to take a sensitive medical database with lots of real cases, put it in a special network architecture called GAN, and then you get a database of fake medical records. These fake medical records might be very useful and effective in, for example, training your system or your algorithm or your deep neural network to do something useful. Once you use only fake medical data, there is no issue of confidentiality anymore, and you are free to do whatever you want. The question is whether the fake medical data is as good and serves all the purposes that the sensitive, true medical database was intended to solve. Now, this is exploding now. These are just 5 examples from 2018. This is becoming bigger and bigger. So let's conclude part 1. Anonymized data is free from privacy protection. There is risk of re-identification. There is quantitative parlance about the risk of re-identification in terms of k-anonymity or differential privacy. There are these applicable laws in the US and in Europe. And then there's this emerging technological workaround, which is GAN-based. And here I want to focus on this first conclusion that anonymized data is free from privacy protection, and just bring this citation that is, one could describe it as somewhere between Marxist and conspiracy-oriented. It says, business-friendly privacy regulators specifically declare that anonymized personal data is not regulated by data protection laws and is therefore fair game and up for grabs by all. This idea is basically that the reason, if you come and ask yourself why is anonymous data free from all these protections, then this person says, and I like him in many ways, that the reason is that the regulators want the big businesses or whatever to have easier access to medical data, so they just have to anonymize it and it's theirs and they can do with it whatever they want. So this is more or less the end of part 1, and we immediately go to part 2, which is short. Part 2 is about following the money. So think about this form. This form is the health record. What we have here, the top part includes identifying data, the personal information of the patient. Here is the medical data, the description of the illness or whatever. So this form, once complete, I say, for example, that it is valued, it has a value of 100 euros for the patient and 0 for the doctor. Why 0 for the doctor? Because the doctor cannot do anything with it. Why 100 euros for the patient? Because the patient can potentially sell it to someone. Perhaps he will sell it to a pharmaceutical. And now, because it is known that his name is this, his address is that, and he suffers from diabetes, then this pharmaceutical will send him commercials every Sunday morning with a new medication for diabetes. So, and the pharmaceutical will be willing to pay some money for that. So I say it is worth 100 euros for the patient. Now, as a confidential patient health record, from the doctor's perspective, there are, of course, privacy protections. The doctor cannot release it to anyone, and the patient consent is needed for any use. The doctor cannot use it for anything except for treating the patient. So here is our doctor, and now I apologize to all the doctors that work in hospitals, insurance providers, or whatever. I'm saying doctors, but I mean the medical provider, basically. That's the correct term. Now, suppose these doctors take their scissors and cut out the personal information, the identifying information. They are left with half of the form that includes just the description, the clinical description of what is going on. They can do it, and they do it all the time. So now we have an anonymized health record. Privacy protections no longer apply, and patient consent is no longer needed for anything. You can do with this whatever you want. And now, what is this value of this anonymized form? It is worth 0 for the patient. The patient, it's not useful for the patient. It is worth something, not 100, but perhaps 10 for the doctor. Why? Because the doctor potentially will sell it to me because I want to do research on this specific illness, and I'm perhaps willing to pay 10 euros for this health record. Okay? So from a situation of a document valued 100 euros for the patients and 0 to the doctor, we are now in a new situation where the value is 10 euros for the doctor and 0 for the patient. So let's think about it. This is a process that is controlled by the doctor. Anonymization is controlled by the doctor. The doctor gains 10 euros. The patient loses 100 euros. What do you say? Is it fair? Is it ethical? Yes.
Can the doctor just generate 1,000 fake records?
They are not fake. They're anonymous.
Yeah, but how do you know?
All this discussion here is under the assumption that people follow the law, the ethics. I'm not interested in criminology in this talk, and I don't have any know-how in criminology. So I'm trying to understand reality under the assumptions that people follow the applicable regulation and law and ethics. Yes?
You were saying that you went from this value to this value, but still the patient can still stand. So it's not that this document doesn't exist in only one copy.
Okay, this is...
So the doctor could have used that, and the patient could still potentially give to
This is an interesting point, and the answer is not clear-cut. For example, in Israel, if you take, for example, an MRI scan, and you want a copy of this DVD or CD-ROM with the data, it costs the hospital 10 euro cent to produce it, but they will charge you probably, or are allowed to charge you perhaps 30 euros for providing you this data. So the data is not easily available, your data is not freely available to you in Israel. Now, in different countries, there are probably different regulations, but it is not trivial. Pardon? תקנות זכויות החולה, this is some Israeli regulation that allows hospitals to charge, even for the first copy. Sometimes they don't. Okay. So I'm skeptical about how ethical it is for the doctor to take 100 euros of patient value and turn it into 10 euros of doctor's value. I think it at least raises an ethical concern that is not often discussed. And from my point of view, the patient should have some control on the anonymization process. I think it's not trivial, it's not obvious that the doctor should be allowed to take a medical record, anonymize it, and then do with it whatever he wants without consent of the patient. So the conclusions of this shorter part of the talk is that by anonymizing, we basically move value in some sense from the patient to the doctor. And I want to raise the question of fairness and medical ethics and informed consent and the possibility of post-anonymization control by the patient on the anonymized health record. Which brings us to part 3, which is, I think, the nicest part of this talk. It includes 5 short true stories that we will try to do quickly. And later on, we will sum them up. So the first story is about a gentleman called John Moore. John Moore was treated for leukemia by Dr. Gold in UCLA in 1976. His spleen was removed, some tissue samples were taken, and the doctor discovers that the blood cells that he takes from Moore are unique. They produce protein that stimulates blood cell growth, white blood cell growth. Now, white blood cells are important for many things, like treating infections and so on. So this is a very useful discovery. Dr. Gold produces what we call a cell line. These are cancer cells, basically. They multiply quickly and they die slowly. So you are able to generate a continuous supply of these cells. He produces them, he patents them, commercializes them, and Gold and UCLA make a lot of money. Moore does not know anything, but eventually he finds out, and he sues because he wants share in the profits. Okay, so this goes all the way up to the Supreme Court of California in 1990, and the majority ruling is that, one, Moore has no property right in the cells. Once these cells were taken out of his body, it's not his property. Furthermore, he has no rights for profits derived from the cells that were taken from his body. The court says, yeah, the doctor should have told Moore about this commercial interest. In terms of ethics, it's a little bit fishy that he did not tell him. But basically, what we learned from Moore, from the case of Moore, is that he has no property right in the cells and in the profits. Now, the court explains, and they're basically afraid that if they rule otherwise, it will really limit research. So they don't want to do this, and that's the decision that they reached. The outcome is that everyone can gain from Moore cells except Moore. This is how we normally discuss the case of John Moore. Everyone can gain from Moore cells except Moore. And Moore, unfortunately, by the way, the treatment was very good. He survived from 76 to 2001, and he died in 2001, aged 56. So what do we learn from Moore? Let's go back to the Declaration of Helsinki that says that for medical research using identifiable human material or data. Look how in the Declaration of Helsinki, human material and human data are treated as similar things. If we combine Moore and Helsinki, we have this thinking that identifiable human data is similar to identifiable human material. Anonymized human data is similar to anonymized human material. If, according to Moore, patient has no property right in the discarded cells, identifiable or not, by analogy, patient has no property right in his data, identifiable or not. Yes?
Could Moore have said that the DNA is providing an identifier?
Wait. This is an old story. It's only the first. So everyone can gain from patient's data except the patient. That's the outcome of Moore, which brings us to Henrietta Lacks. Henrietta Lacks was born in 1920 in Virginia. She was a mother of 5 by 1950. After the birth of her fifth child, she had a problem with her stomach. She went to Johns Hopkins, which was the only hospital in the area admitting black patients, 1951. During treatment, samples were taken from her cervix without permission or knowledge. This was the practice at the time. They took samples. And she dies in 1951, unfortunately, and she was very poor. She was buried in an unmarked grave. Her cells, again, are cancer cells. They reproduce at a very high rate, and they developed into what is called the HeLa for Henrietta Lacks, immortal cell line. So because they grow fast and they die slowly, you can produce them in large quantities. And her cells are used for everything. For example, they were used to develop the polio vaccine. They are used for everything. They used to test human sensitivity to cosmetics, for example. Someone speculated, it is known to be exaggerated, but I'll still say that, someone speculated that so far there are 50,000 tons of HeLa cells produced. This probably is not the correct number, but I've mentioned it. 10 years ago, there were 11,000 patents, 60,000 scientific articles, and thousands of careers that are either cite or due to the HeLa cell line. okay, these cells are really powerful. They are produced so fast and they don't die. They contaminate, in laboratory settings, they contaminate other cell cultures. Okay, and then the doctors are in panic because they don't know if their cell culture is what they think it is or perhaps HeLa cells that contaminated it. So they want to know what are the properties of the real HeLa cells. So they go back to the family and ask for blood samples. They don't provide any explanation, but the family finds out about the use of the HeLa cells in 1975. Remember, this is not a socially strong American family. In 2013, someone publishes the DNA sequence of one strain of HeLa cells. Okay, now this now is source for stress for the family because now their genetic information is more or less public domain. Okay, and this has many consequences. And then there is some NIH-sponsored research that sequences another strain of HeLa cells. They go into discussion with the NIH, and the eventual decision was that there will be some committee where they will be a minority, but they will be in the committee, and this committee will provide oversight to how this DNA sequencing data is distributed to researchers. So the family got some involvement in the control. And her grave is somewhere near here. No one knows where because her grave was not marked. Third story. Third story is about a disease called Canavan disease, the Greenberg family. The Canavan disease is fatal genetic disorder, progressive brain damage, children die. I should say it is typical to a part of to some Jews from Ashkenazi origins, whoever know what it means, including, like I belong to this group that is susceptible to Canavan's disease. We have this Greenberg family in Chicago, I think, children with Canavan's disease. And then there are non-profit organizations that develop a confidential Canavan disease database. So they have this big book that they say, well, this family had a child, he had Canavan's disease, this happened, then that happened, then he died, then someone treated this way, someone treated that way, this treatment did this treatment did that. They had a whole catalog of Canavan disease cases. But the Greenberg family, I think they had twins with Canavan. They are very, very concerned. So they approached Dr. Matalon from University of Illinois in Chicago, and they tell Dr. Matalon, we want you to study Canavan's disease. And they provide him tissue. They provide him blood samples from the family. Furthermore, these non-profit organizations that hold the database contact other families and tell them, well, you go to Dr. Matalon and you provide these blood samples. And they also collect money. And they fund Dr. Matalon's research on Canavan's disease. Then, at some time, he starts working with the hospital in Florida, Dr. Matalon. He isolates the Canavan gene sequence in 1993. He develops a genetic screening test for Canavan. This is very important because now potential parents are going to know whether they have the risk of having Canavan disease in their children. The non-profit organizations are very happy, and they start offering genetic screening tests based on the work of Dr. Matalon. But Dr. Matalon and the hospital patent the gene sequence. It is possible, and they demand royalties. Now, the family is very unhappy. The family and the non-profit organizations are very unhappy. So they file a lawsuit, and they don't want commercialization. I mean, they went to Dr. Matalon. They paid for it. They gave him all the data. How come you now patent, you do not allow us to provide the community with this screening test? So it goes to court, and the court dismisses most claims, except one claim. And that is the claim of a legal doctrine called unjust enrichment, which basically says that since the nonprofit organizations and the family, they collaborated and they invested and they were part of the team more or less in that way, they should be entitled to something. Okay? And then, of course, there is an out-of-court settlement. There is no action of the court. It is decided out of the court, and that's the end of this story. Let's go to the fourth story. This is the Havasupai tribe in the Grand Canyon. This is especially for you, Bart, because it has to do with diabetes. It's a small Native American tribe, 700 people. They live in the Grand Canyon, deep in the Grand Canyon in Arizona. The word Havasupai Havasu is from blue-green water. Perhaps you see here how beautiful it is. And Pai is people, and they speak their own language. These 700 people have their own language, and they have a devastating rate of diabetes. Now, they are interested because they know that other Native American Indian tribes had some genetic issues with diabetes, so they want some research to be carried out. They approach a researcher from Arizona State University regarding diabetes. They tell him, well, we have this problem of diabetes, please help us solve it. So in 1990, there is a collection of blood samples. Everyone is encouraged to give blood samples to these researchers, and they sign a generic consent form in English that says, like most consent forms, the doctor, the hospital, the university is allowed to do with the data whatever they want, and nobody cares. You know how these consent forms are drafted. And then there are not so many discoveries about diabetes. Their diabetes is not related to the diabetes of the other tribe, but there are some interesting findings that are published. For example, it is discovered that their origin is from Asia. They came from Asia through the Bering Sea, many, many centuries ago. Now, this goes against the tradition of this Indian tribe and against their claim for land rights, because they tell the United States of America, we emerged in the Grand Canyon. We've been in the Grand Canyon forever. This land belongs to us. And now this genetic research comes and tells, well, some 1,000 years ago, you actually came from Russia. So you're Russians, not only you're not from here, you're Russians. And then it is also discovered and published that there is a lot of inbreeding. Not surprising, given that this is a really small tribe. But this goes against their religion and faith. So the inbreeding is really an insult. So there is a lawsuit. And the lawsuit claims, as an interesting claim, it claims cultural, dignitary, and group harm to participants. So in 2004, there is a lawsuit with an interesting claim. And the claim is that the tribe suffered from cultural, dignitary, and group harm because of the use of the material, of the human material by the researcher. And again, there was a settlement, there was some compensation, and the samples were returned to the people who contributed them. The last of these short stories is about Dr. William J. Catalona. Dr. Catalona is a leading urologist. He's a specialist in prostate cancer at an institute that I will call Institute A. Actually, it is Washington University of St. Louis. And he is there from 1976 to 2003. And patients donate tissue samples for research. And he, over the years, assembles a huge, huge, huge biorepository for basically prostate cancer. And then he moves to Institute B, which is Northwestern University. And all his patients, past and future or whatever, they all like him very much, and they are happy with his research, and they're happy with the use he made of their donations of blood samples. So they sign forms that say, we want Dr. Catalona to take our samples with him from Institute A to Institute B. Okay? but then Institute A refuses to release the samples. Okay, so this goes to court. And the court says that the samples are owned by Institute A. Why? Because after the donations of the samples, what the patients say about the use of these samples is irrelevant. Okay? So no control of the material once it has been donated. And the interesting part is what the Washington University of St. Louis says that it thinks is right. They say the following: if a participant withdraws his consent to participate, any one of the three things may happen. Okay? Washington University may, 1, destroy the sample, this is fine. 2, store the sample without using it. This is questionable, I would say. And then 3, they say if the patient does not consent anymore or removes his consent, we can remove all the personal identifiers from the sample and continue to use it in exempt anonymized research. So what we have here is the treatment of human material, at least that's the position of the university. The treatment of the human material is completely analogous to the treatment of human data. And if human data can be anonymized and then used for whatever they want, human material can also be anonymized and used for whatever they want. So what are the conclusions from these cases? 1 is that the patient has no property right in his data. But in an extreme case, like Henrietta Lacks, the patient can get some control. Like if you made more than $100 billion from that, then perhaps, and we're lying for a century, then perhaps you can get some control. Everyone can gain from the patient's data except the patient, that's Moore. Unless the patient was an investing partner, like in the case of the Canavan disease, they actually funded and contributed to the whole thing, or if you caused a group harm, like you did something that really annoys the whole group of people from whom you collected data. Human tissue can be anonymized and used just like data. And now we have to sit, relax, and think whether we like this legal situation. So what are the conclusions from part 3? 1 is that the court's fear of a chilling effect on medical research. That's what's behind their policy. Tissue and data are the same thing. This is especially true once you have DNA sequencing. The distinction between data and human material is practically gone. Tissue is anonymous just like data, and of course stories about human tissue don't have happy endings. If you think about all these 5 cases, nobody's happy there. Which brings us to the last 4th part of this talk, and that's about the Oregon Senate Bill 703. Oregon Senate Bill 703 from the state of Oregon in the United States. And the background is there is this company called humanity.co that creates an app that they called My31. Why My31? Because in the UN Declaration of Human Rights, there are 30 rights, 30 principles. And they want to say that ownership of data should be the 31st principle of human rights. And what they want to do is to give people legal control of their medical data through blockchain technology. Okay? So they envision a situation where users set the terms of data sharing and can get paid for giving access to their data. Okay? And they create or want to create this platform, computational platform, that includes the country and the industry and the patient and whatever. So they will have this huge software platform that will allow patients to provide access to their data for interested commercial users for pay. Okay? Only problem is that this is not completely compatible with the legal standards in the United States or anywhere else. Okay? So now we have Oregon Senate Bill 703, which I like very much, and it was sponsored by all these famous representatives and senators. And we see here below that it is at the request of humanity.co. Okay, so it did not come out of the blue. It came out of the legal department of humanity.co. So what does the Oregon State Bill 703 say? First of all, it prohibits entities from transactions relating to a person's health information or de-identified data without consent, which means that this practice of the doctor erasing the patient's name and from the form, and from that point, the form is free for all to do whatever they want. According to this bill, this is no longer possible. It allows a person they need consent from the patient. The bill allows a person to receive money in exchange of the authorization. You want to use my data? You can pay. It prohibits discrimination or penalty against people who do not want to give consent. Okay. So if we compare the Oregon bill to the applicable laws in the United States and in Europe, in the United States, the HIPAA, and in Europe, the GDPR say that the identified data is not protected. The Oregon bill says, it's 703, not 073, that consent is required also for the identified data. So once this bill is released into the public knowledge, there is immediately opposition. Now, the opposition comes from interesting sources. For example, Consumer Reports. Consumer Reports is a big thing in the United States. They say that this bill turns the basic right of privacy into a luxury out of reach of lower-income Oregonians, because they will need the money that people offer them for their data. They say it will lead consumers to sign away their privacy without understanding what they're doing. The consumers are really ignorant, stupid people. And then there are other people that say this bill is a Trojan horse for big companies that want to purchase private data. And someone else says it is introduced by a company that is trying just to make its software platform the legal standard. And yet, some other people say it's going to be a logistic nightmare for medical research. So this goes, it's going to have negative impact, it's going to be a nightmare. So this goes back to the Senate of the state of Oregon, and the Senate wipes out this bill. They send it to the recycling bin, and they establish a task force on protecting health information, which is due to report on December 1st, 2019, which is pretty soon. Nobody knows what it will recommend, this task force, but my thinking is that it is not going to suggest anything as dramatic as the original bill that makes anonymized data subject to consent. And from a political point of view, you have these poor Senate members that are torn between two powerful pulling forces. One of them is the outrage of consumers because of Facebook and Cambridge Analytica and all that. So consumers really want to feel that the legislators are concerned about proper use of their data. So this is one magnet. And the other magnet is that these regulators are really business friendly. So, and they want the big companies to be happy, and they are torn between these two concepts and they don't know what to do. And there is this famous idea that when in doubt, form a committee. So they form the committee. In difficult cases, form a committee. So this is basically the end of my talk, and I will end it with this very famous anonymous guy, Budapest. This is from Budapest. This is the anonymous chronicler of King Bela from the 12th century. I don't know about King Bela, but the statue of his chronicler is there in Budapest in a very nice place. He's anonymous yet famous. Thank you very much.